So doctrine of ultra wires, it means simply beyond their powers, beyond the power of company. In yesterday's example, we had seen that Bata is selling footwear. It is written in their MOA that it will sell footwear. But if Bata tomorrow starts selling medicines, it starts producing pharmaceutical products, it starts producing the medicines, they set up a pharma plant, then that is ultra wiring the memorandum of association that they have prepared. So whatever is your scope, whatever things you want to do in the future, also in your business, you have to mention in MOA. If you are not mentioning, you can amend it later on. But without amendment, if you are doing something which is more than the power written in your memorandum of association, you will be liable for the punishment. And that is doctrine of ultra vire. That is beyond your power, you're doing something wrong. Now, let's see what they have said. Meaning of the term ultra wires is simply beyond their power. You're doing something beyond the power you have. Who gives you power? Companies Act gives you power, and then MOA is something which gives you the power to work in that manner. Now you are doing something against the Companies Act. Companies Act says whatever is written in your MOA that you can do. If you're doing something more than that, something wrong than that, then that will be a wrong thing, and you are doing something beyond the powers. The legal phrase ultra vires is applicable only to acts done in excess of legal powers of the doers. It is, you are doing some act which is in excess of legal powers. You don't have the legal power to manufacture medicine. Still, you are doing it. This presupposes that the powers in the nature are limited. This shows that whatever powers you have are limited. Whatever you mention in MOA, that is the limit where maximum you can go. It is a fundamental rule of company law that the objects of a company, as stated in its memorandum, can be departed from only to the extent permitted by Act. Only to the extent that is permitted by Act. Whatever is written in MOA, that much only Act permits you. Thus, far and no further. After this, beyond this, you can't do anything. In consequence, any act done or a contract made by the company which travels beyond the powers not only of the directors but also the company is whole wide, void and inoperative in law. If directors are getting into some action which it was not allowed to them, directors get into some agreements with foreign companies for producing for the research and development, but it was not written in MOA that they can get into foreign country agreements or foreign company agreements. If they are getting into it, or the company as a whole is getting into agreements with foreign company which was not mentioned in the MOA, then that activity is void and inoperative in law. Inoperative means not allowed in law, not functional in law, and is therefore not binding on the company. It is not binding on the company. Company is not liable for it. If foreign company tomorrow comes and says, you said that you want the research and development, we have done research development, give us the money. What they will say? It is not binding on us because it was not written on MOA. Now we don't want to give you the money. So they have the power over here. On this account, a company can be restrained from employing its funds for purpose other than those sanctioned by the memorandum. I told you, like they are using their funds for the particular things where they are investing in research and development with foreign company. In their MOA, it was written that they can do research and development with Indian company. But now they are doing with foreign company. Indian company now cannot remit money to foreign companies because it was not written in their MOA. Likewise, it can be restrained from carrying on trade different from the one it is authorized to carry on. It is not allowed for them to carry on the trade of medicines because it was not written in their MOA. If it was written in their MOA, they could have done so. Are these first two paragraphs clear to you people?
Yes, ma'am.
Yes, ma'am.
Okay. The impact of doctrine of ultra vires is that a company can neither be sued on an ultra vires transaction nor it can sue on it. Now, I told you, like in MOA, it was not written about the foreign company transactions. But Bata does some research development with a foreign company, ABC, INC. In foreign companies, the name is INC. Okay, we have limited, they have INC, incorporation. So it does some transactions for research and development. right? They do some transaction of research and development. Now, in this research and development transaction that they are doing, what happens is they say that we want the research and development to be done, but in their MOA it was not written. Now, if this foreign company ABC Inc. does not do the work, does not do the work, Bata cannot sue ABC Inc. because if they are doing anything ultra wires, it was not written in their MOA to do any transaction with foreign company. Still you did. So on this ultra wire transaction, you cannot sue the other person. Or if tomorrow it happens, they have done all research. ABC Inc. did all research and development, but Bata did not pay the money for research and development. They only took the valuable inputs and now they are not going to pay the money. So other party, the ABC Inc. also cannot sue you because this is a ultra wires transaction. Since the memorandum is a public document, it is open to public inspection. Therefore, when one deals with a company, one is deemed to know about the powers of the company. So, your MOA is an open document. Before ABC Inc. enters into contract with Bata, they have to read the MOA and see if Bata has the power to get into medicine business, if the Bata has power to get into foreign company transactions. If in spite of this, you enter into a transaction which is ultra wires of the company, you cannot enforce it against the company. Even if ABC Inc. is knowing that Bata cannot enter into foreign transaction, in MOA it is not allowed to enter into foreign transaction. Still ABC Inc. enters into transaction with Bata, that is a foreign company transaction. Then you can't enforce it on company. Then ABC Inc. will not be able to demand money for the research they are doing from Bata India. Is this example and paragraph clear to you, Equal?
Yes, ma'am.
Yes, ma'am.
You want me to slow it down a little?
It's okay, ma'am.
Oh, it's okay, right? Because the basic crux of ultrawires, everyone has scared you that doctrines are difficult, but doctrines are very simple. That is why we are doing it in the morning session, because it should be going directly to your mind that if anything beyond the power of MOA you are doing, you are not following the objective, you are doing something beyond the objective, beyond the power, directors are doing something, companies entering into something, that is called as doctrine of ultrawires. You are doing something beyond the power that is mentioned in your MOA and companies. Let's see what the institute has given an example. We'll see that and read it. Okay. If you have supplied goods or performed service on such a contract or lent money, you cannot obtain payment or recover the money lent. So if you're doing any contract of ultra wires and in that contract you lend some money, now what you do is Bata give some advance money to ABC Inc. foreign company for research and development. Now ABC Inc. later on comes to know that this Bata is not allowed for foreign company transaction, and still they are doing ABC like foreign company transaction. Then this money will not be forfeited. This money they will not give you back. If you have supplied goods or performed service on such a contract or lent money, you cannot obtain payment or recover the money lent. You cannot ask ABC Inc. to give back you the money because you have done an ultra wires transaction. If ABC Inc. was in the case, they are doing research and development and then they are asking for the money. You can't ask money from Bata because they are doing a wrong transaction. They are doing something beyond their powers. But if the money advanced to the company has not been expended, if this money which was given to ABC Inc., this is not spent already, this is not expended, then you can give back the money. Then the lender may stop the company from parting with it by means of an injunction. This is because the company does not become the owner of the money, which is ultra wires of the company. As the lender remains the owner, he can take back the property in specie. If the ultrawires loan has been utilized in meeting lawful debt of the company, then the lender steps into the shoes of debtor paid off and consequently he would be entitled to recover his loan to the extent from the company. Now, here what they have said, if you are like you have not spent this money, ABC Inc. has not spent the money, and then both of them come to know that in our what you call it, in your transaction, if it is not mentioned that you can recover the money, you can't get into a transaction. If MOA it is not written that you can do a foreign transaction, then you come to know about this picture that in MOA it is not written. And if we enter into a foreign transaction, government will give us some penalty. That time you can repay back the money if you have not spent it. Okay, this is because company does not become the owner of the money. Here, ABC Inc. will not become the owner of the money over here. They have just taken advance money. They have not spent it and they have not done any work. That is why you are not the owner of the money. If work is already done, you are the owner. As the lender remains the owner. Here, Bata is the owner. He can take back the property in specie. Bata can take back the money from the ABC Inc. If the ultra-wires loan has been utilized in meeting the lawful object of the company. Now, if this loan that was given, advance money that was given, is done for doing some lawful objective, like lawful debt of the company has been already used, lender steps into the shoes of debtor paid off. He will become a debtor paid off. He will say that, okay, I have paid some money to my debtor, and consequently he would be entitled to recover his loan to the extent from the company. Now if a Bata Inc, Bata Limited gave rupees 5 crore on 1st of May 2024 and ABC Inc started research and utilized 2 crore, right? But on 10th of May they get to know that Bata is not allowed to enter into transaction. Bata is not allowed to do transaction with foreign company. So on 10th of May, whatever amount is remaining that is not spent on the work will be returned. What they have said, they have the right to recover their loan to the extent from the company. How much they will recover back now? 3 crore, which is unspent, that they will recover back. Is this example clear to you people?
Yes, ma'am.
Okay, only one said yes. Others, are you still confused? You need some more help. 2 of them have confirmed. 3 of them have confirmed. Okay. Now, so simple thing which we can remember here is if some money is lent already, first of all, you can't recover it. But if the amount is not spent, then you can recover that amount. If amount is partly spent, like I told you, 2 crore is already spent. So now you can recover the remaining amount, because when you get to know that this transaction was not allowed, that time whatever remaining amount is there, you can recover. An act which is ultra vires, the company being void, cannot be ratified by the shareholders of the company. If some act is an ultra vires and company has done something wrong, it cannot be ratified. Ratified means corrected by the shareholders of company. Shareholders of the company cannot ratify it, correct it. Scroll a little. Sometimes act which is ultra vires can be regularized by ratifying it subsequently. Now later on some acts can be ratified. They can be corrected later on. Like we saw that 3 crore will be received back and we will not enter into further research and development. For instance, if the act is ultra vires, the power of directors, shareholders can ratify it. If it is ultra vires, the articles of company, the company can alter the articles. If the act is within the power of company but is done irregularly, shareholder can validate. If it is written in the articles of the company and you did something beyond the power that was given in the articles of company, that type of acts you can ratify. The shareholders also can ratify that type of. Okay, is this para clear?
Yes, ma'am.
Now, why this doctrine came, from where this came? It was enunciated, it was emerged from this case law. We will be seeing this case law. Ashbury Railway Carriage and Iron Company Limited versus Ritchie. Now, let's see the facts of the case. In the question, what they will do is, they'll give you the facts of the case. Now we are analyzing what are the facts. Facts of the case are, main objects of a company were to make or sell, lend or hire railway carriages and vehicles. They are going to make the railway carriages. They are going to sell it. They are going to lend on hire. They are going to give it on rent, railway carriages and vehicles. to carry on the business of mechanical engineers and general contractors. They will also be doing mechanical engineering work of this railways, railway carriages and wagons, and they are going to take general contracts to purchase, lease, and sell work mines where they are working the mines and all. They can purchase, they can sell them, and they can take it on lease or give it on lease. To purchase and sell as merchants or agents, coal, timber, metals, etc. Now they are working in mines, etc. So they have excess coal, timber, metal, etc. things. They can sell them, purchase them, or they can act as agent for other people. This was all the points that was mentioned in their main objective. Now what they did is, directors of company entered into a contract with Ritchie for financing the construction of a railway line in Belgium. Directors entered into a contract with Ritchie, Ashbury Railway Carriage and Iron Company. This is your Iron Company Limited. They entered into a contract with Ritchie for financing the construction of railway line in Belgium. They took some finances and they are going to construct a railway line in Belgium. Now they are going to construct in Belgium. Was this written in their MOA anywhere to construct a railway line in another country or to take financing for construction of such railway line? They are going to make railway carriages and wagons. They will be doing mechanical engineers and general contractor thing. They can lease, purchase or sell the work mines. They can purchase and sell or agents of coal, timber, metal. Nowhere the name of railway line is given. Still they are doing it. Let's see further what they've said. And the company further ratified this act of the directors by passing a special resolution. Company, however, repudiated the contract as being ultra vires. Now, company has cancelled this contract by saying it is ultra vires, and they passed a special resolution. And Ritchie brought an action for damages of breach of contract. Ritchie, what he said? You were the people who took the finances from me, and you said that we will be constructing a railway line in Belgium. Now I need the damages. I want my money back. His contention was that the contract was well within the meaning of the word general contractors and hence was held by the court that, within its powers. Moreover, it has been ratified by a majority of shareholders. Majority of shareholders cancelled the contract. However, it was held by the court that the contract was null and void. What he thought, Ritchie thought that this is under your general contractors. You can take any contract, you can build the railway line, etc. That is your general contract. It is said that terms general contractors was associated with mechanical engineers. That is, it had to be read in connection with company's main business. What court decided? That this general contract was relating to railway carriage and wagons. You can take general contract of building railway carriages and wagons, but you can't take a contract of building the railway line entirely. If the term general contractors was not interpreted, it would authorize the making of contracts of any kind of every description, for example, marine and fire insurance. They said if we don't restrict this general contract to the main objective of making or selling or lending or hiring of railway carriages and wagon, you can enter into any contract. If today we don't restrict only to building railway carriages and wagons, tomorrow you will say we are going to take fire insurance, marine insurance. Tomorrow we are going to build a ship. Then we are going to build a fire extinguisher. Then we are going to build some fire, what you call it, fire alarms and everything. You will do any kind of work. Now we have to restrict you. That general contract means general contract of building railway carriages and vehicles. Okay, so the court had restricted that power, and this was like ratified by every shareholder. Majority of shareholders cancelled this contract. Okay, is this case study clear to you? Case law clear to you?
Yes, ma'am.
An ultra vires contract can never be made binding on the company. You can't bind the ultra vires contract on the company. It cannot become intra vires by reason of estoppel, acquiescence, lapse of time, delay, or ratification. You can't say that by estoppel we did that in good faith, or we were acquainted with this. We knew how to work in that manner. We were well acquainted. You can't say. lapse of time. By now the time has passed and we did not correct the MOA. That's why please allow us this. This won't be allowed. Delay or ratification also. You were going to correct the MOA, but you got delayed. If you have got delayed, correct the MOA first and then enter into the contract. Okay. The whole position regarding the doctrine of ultravires can be summed up as when an act is performed which, though legal in itself, is not authorized the object clause of memorandum, or by statute, it is said that ultravires of company and hence null and void. It is said that you can enter for research and development, but you have written in your MOA that we will enter for research and development only in India. So how you can enter in foreign company? It is not written in your MOA. If you are doing something beyond your MOA or the statute, it is called as ultra wires of company, and this transaction will be null and void. An act which is ultra wires, the company cannot be ratified even by unanimous consent of all the shareholders. Even if all the shareholders say that this is a valid transaction, we are doing a right thing, you can't correct that wrong thing that you have done. You can't justify that action. An act which is ultra vires the directors but intra vires the company can be ratified by the members of the company through a resolution passed at a general meeting. Now your your directors didn't have the power to take loan. It was written in the MOA that they can take loan. In MOA it was written max loan by directors without permission of shareholders is 50 crore. But directors take a loan of rupees 75 crore. Now this action is already done by the company, right? It is ultra wiring the MOA that was given. But company says, okay, this loan was taken for this purpose. We are starting a new project. They ratify it, they approve it, justify it by passing a special resolution in the general meeting. Then you can say this act is not ultra wire. Okay. Are these three first points clear to you people?
Yes, ma'am.
If an act is ultra vires the articles, it can be ratified by altering the articles by a special resolution at general meeting. If you're ultra wiring, if you're not following, going beyond what is written in your articles of association, then you can ratify it, then you can correct it, then you can make the changes by passing a special resolution at a general meeting. But if you're doing something wrong or beyond the power of MOA, that cannot be ratified. Let's go ahead. However, the disadvantage of this doctrine outweigh its main advantage, namely to provide protection to the shareholder and traders. Although it may be useful to the members in restraining the activities of directors, it is only a nuisance insofar as it prevents the company from changing its activity in a direction which is agreed by all. Again, the purpose of doctrine of ultravires has been defeated, as now the object clause can be easily altered by passing just a special resolution of the shareholders. Now what they have said, disadvantage of this doctrine is that already it had a main advantage to protect the shareholders. Now it is very much easy. You can make an amendment, you can file the MOC amendment, MOA amendment on MCA website, and your objective will be changed. Earlier, if you want to change the objective, there was a very lengthy procedure. Sometimes the ROCs won't allow it also. But now it has become very easy. And this is done because businesses want to enter into various activities. Now, if tomorrow Bata wants to enter into your real estate business, Bata wants to enter into a real estate business and Bata has not mentioned in their MOA, then what they will have to do? They will have to take the MOA done, like a MOA amendment to be done, and all the procedure is to be done, and special resolution is to be passed for it. But this is like every shareholder says we want the maximum benefit of the company. If Bata will get maximum benefit of real estate business, why you are taking permission? You just go and enter into it. But our Companies Act says that if it is not written in your MOA, you can't enter it. So it is just a nuisance. They say that it is just a nuisance, waste of time, because it is preventing the company from changing its activity in a direction which is agreed by all. All the shareholders will say, okay, if Bata you enter into real estate business, tomorrow you start buying and selling of the properties, we will be getting the benefit. We are not going to stop you. But this doctrine of ultra vires is preventing it. Then they have a solution also, that you can change the object clause and you will be free out of this. Okay, is this point clear?
Yes, ma'am.
Right, what they have said is disadvantage of doctrine outweighs its main advantage. Main advantage of doctrine is to provide and protect the shareholders and creditors from some wrongdoing. The disadvantage of doctrine is that you don't allow the company to do something different activity. If all are agreeing, still you don't allow the company to do it. For this, you have to first pass the special resolution in the general meeting, and then only you can do it. So this is a hindrance, or this is a hurdle for the companies. Because in today's world, we can see that every day companies want to enter into some new business, and that is going to be profitable. They are trying to work day and night to get the profits. So fetching in different areas is the need of time. Okay. Is doctrine of ultra vires clear to everyone? I need the approval of everyone. Is it clear? Gopika says it's clear. Ishwar, Lakshida, Sharmita. Okay. Okay. Now, let's go ahead. Articles of association, we have seen the activities that they are going to do, rules and regulations which are going to be done, internal affairs that the company will be doing to achieve the main objective is given in articles of association. Now, let's see what is doctrine of indoor management, or you can say what is exception to doctrine of constructive notice. Now, first they have explained you doctrine of constructive notice. Let's see what it says. Section 399 of the Companies Act 2013 provides that any person can inspect by electronic means any document kept by the registrar, or make a record of the same, or get a copy or extract of any document, including certificate of incorporation of any company, on payment of prescribed fees. What they have said, any person, suppose I am the shareholder of Reliance. Reliance shareholder, right? I have the power that I can inspect any document kept by the registrar. I can ask the registrar, I want to check this document, if I have submitted this document or not. Make a record of the same. If I have submitted any document which is the PAN card, and I don't have the PAN card of the company, I don't know what is the PAN number of the company, I will tell them to give me a copy of it, record or copy of it. I will just click a picture of it and that will act as a record. Or I will take the copy of it, Xerox print of it, extracts of any document, including certificate of incorporation. I can also ask for the certificate of incorporation of Reliance on payment of a prescribed fees. But I will have to make some fees payment. I will have to give some payment to the company, to the registrar of companies. The memorandum and articles of association of a company, when registered with registrar of companies, become public documents. When you register your MOA and AOA, that is becoming a public document. We saw yesterday Reliance's MOA and AOA. So that is a public document. Anyone can see it, and they are available for inspection to any person on payment of a nominal fees. If I pay nominal fees and ask the company that I want the financial statements of Reliance of 2014-15, right? I say them I want 2014-15 financial statements. They will give me when I pay the nominal fees. In other words, Section 399 confers the right of inspection to all. In 399, it is giving a power to everyone to inspect the books of accounts, or to inspect the documents that are freely available, publicly available of a company. It is therefore duty of every person dealing with a company to inspect its document and make sure that his contract is in conformity with the provisions. But whether a person reads them or not, it will be presumed that he knows the contents of document. This kind of presumed or implied notice is called constructive notice. Now, if Reliance enters, let me erase these things for you. Now, Reliance is not in which sector, that sector will try to take an example. Reliance enters into airline business. Okay, Reliance want to enter into airline business, and some airline is trying to contact them. Suppose Indigo is trying to contact with Reliance. So when Indigo wants to contact with Reliance, Indigo will read what AOA and MOA of the Reliance Limited, Reliance Industries Limited. And even though if they are just taking the documents, they are downloading that file of AOA and MOA, it will be presumed you have read entire documents. You know the contents of the document. This presumption that you know about AOA and MOA before entering into a transaction with that company is called as constructive notice. When it is assumed that you know the details about the company's AOA and MOA before entering the transaction, this is called as constructive notice. You were aware about the facts of the company, what is the scope, what is the objective of the company. This presumption that company's act has given, it presumes, it is implied that you have notice about everything. You are aware about all the details in AOA and M. Okay, that is what is constructive notice. Is the meaning of constructive notice clear to you people? Yes or no? Okay, Gopika says she understood. Lakshita, Sharmita. Okay. Now, so we can say when a company who is going to enter into contract with other company, it is deemed, it is considered that you have knowledge about everything of that company. If I am going to enter into CA, like when you were trying to enter into the CA subject, it is presumed that you CA course when you were going to enter, it is presumed that you have read all the documents or all the information about the CA course, then only you are entering it. That is called as constructive notice. By constructive notice is meant when a person reads the documents or not, he is presumed to have knowledge of the contents of document. He is not only presumed to have read the documents but also understood them in their true perspective. And it is also considered that you have read the documents, and even if you have not read, you know what is written in that document. You have read the document and you understand the document and you understand the documents, right? It is expected from you. This is doctrine of constructive notice. Every person dealing with the company not only has the constructive notice of the memorandum and articles, but also of other related documents such as special resolutions, etc., which are required to be registered with registrar. So you just don't have to be aware about AOA and MOA. You also have to be aware about special resolutions which are passed and which are registered with registrar of companies. So when we check about a company, we want to invest money also, we should be aware, we should have read all these type of documents, which are your AOA, MOA and special resolutions, which are registered with the registrar of companies. Any special resolution is passed, it will be registered with the registrar. So we have to read all these so that we know how the company is going to work. Is this meaning clear to you people, these 2 points? Okay, it is assumed that it is clear to you people by the thumbs up. Yes. If a person enters into a contract which is beyond the powers of company as defined in the memorandum or outside the authority of directors as per memorandum of articles, he cannot acquire any rights under the contract against the company. So this is again ultra wire they have given, that beyond the powers of company, if you are doing anything or you are doing outside the authority of directors, directors don't have the authority of taking a loan of 75 cr, still you give the directors a loan of 75 cr, so you are doing wrong over here, and he cannot acquire any rights under the contract against the company. So the bank, if SBI is giving loan of 7,500 crore to Reliance, but they can only give loan up to rupees 5,000 crore. Like Reliance can take loan only up to 5,000 crore, and you have given 7,500 crore. So that is where you are going wrong, and you are like you don't have any right to recover the excess amount. This 2,500 crore, if Reliance does not pay you this 2,500 crore, that is your debt. That is your amount sunk cost. That is that amount is gone now. You can't recover this. Okay. Now, what is given further? Doctrine of indoor management. Now we learned about constructive notice. Now let's see what is indoor management. Okay. 1 second. Doctrine of indoor management. The doctrine of indoor management is an exception to the doctrine of constructive notice. The aforesaid doctrine of constructive notice does in no sense mean that the outsiders are deemed to have notice of the internal affairs of the company. When we are saying that we should be aware, like if I am the investor in Reliance, I should be aware about all the data of Reliance, but I cannot know what are the internal affairs of the company, what are the internal affairs that Reliance is going to do. I shouldn't be aware. It is deemed like we shouldn't be having the information about the internal affairs. For instance, if an act is authorized by the articles or memorandum, an outsider is entitled to assume that all detailed formalities for doing that have been observed. This can be explained with the help of landmark case Royal British Bank versus Turkand. This is the doctrine of indoor management, popularly known as Turkand rule. Now, here, suppose I know that Reliance can take a loan of rupees 500 crore, right? So what I will think is that Reliance has taken a 500 crore. For taking this 500 crore, they have to give the projections that these are our future profits and this is what we are going to do in future. All these details they have to tell. Along with this, they also have to comply with other requirements. They have to give their document, they have to give a security, etc. So these are all internal affairs. This internal affairs is not written in your MOA AOA. What they have written that your AOA or MOA contains that it can take a loan of rupees 500 crore maximum. For this 500 crore, what all things are to be done, that is an internal matter. I don't have to do anything with that. So it is not expected by a person who is an outsider. I am just an investor, I am an outsider. I am not the person who is liable to anything. I am not one who should be knowing about the internal affairs. Okay, is this example clear to you, like the Reliance example I took for you people? Yes or no? I have to see the participants. Another example. Okay, 1 second. Did we end up over here? Second. Now, if we say that tomorrow Tata Motors is going to give ESOPs, they have the ability that they can give shares otherwise than cash. I had explained you shares otherwise than cash means instead of salary, you are giving instead of giving bonus, you are giving the employees shares, right? So that is called as ESOPs. That is employee stock option plan. Employee have the option that they can take shares instead of money. Instead of taking the money, instead of taking salary, they have the option that they can take shares. Now, Tata Motors, in their AOA, MOA, it is written that you can issue ESOPs to the employees. But for issuing ESOPs, there are certain conditions to be satisfied. What is the condition? Employee should be working for 3 continuous years. He should not be leaving the company for 3 continuous years. He has to hold the shares taken, hold the shares for 1 year. So these are the conditions. Now, when I am saying that I want to become an employee of that company, I am just applying for Tata Motors. I'm applying for an interview in Tata Motors. And I know this company has the policy of giving the ESOPs. So that time I will not know about these internal conditions that employee should be working for 3 years, hold the shares for 1 year. These are internal conditions. How I will know? I'm just doing an application on LinkedIn, on Naukri.com. I'm just applying for it. I'm an outsider. I don't have knowledge about the internal affairs. Clear? Is this example clear now?
Yes.
Okay. Everyone has understood. Gopika, Lakshita, Sharmita.
Yes, ma'am.
Okay. So this doctrine came out from the landmark case of Royal British Bank versus Turkand. So let's see what this case was. What are the facts of the case? Turkand versus Royal Bank of India. Mr. Turkant was the official manager, liquidator of the insolvent Cameron Colebrook Steam, Coal and Swansea and Logor Railway Company. It was incorporated under the Joint Stock Companies Act 1844. So earlier they used to have Joint Stock Company Act. The company had given a bond of 2000 to the Royal British Bank, which secured the company's drawings on its current account. Now, what they have given a bond to the Royal British Bank, and they secured a drawing on its current account. They took a loan, they gave a bond and took a loan for their current account, and they took it in their current account. The bond was under the company seal. This bond was having a company seal, signed by 2 directors and the secretary. When the company was sued, it alleged that under its registered deed of settlement, articles of association, directors only had the power to borrow up an amount authorized by company resolution. A resolution had been passed, but not specifying how much the directors could borrow. What they said is, I earlier also told you that Reliance can only borrow 500 crore. That is without the permission. If you want to borrow more, you need the permission. So what these people said is, the law said that if you are borrowing an amount, you are borrowing 2000. So this should be authorized by your company resolution. Company should pass a resolution. All the members should give the consent in the resolution. Now they passed a resolution, but in the resolution, it was not written how much the directors could borrow. Held, it was decided that the bond was valid, so the Royal British Bank could enforce the terms. He said the bank was deemed to be aware that the directors could borrow only up to the amount resolution was allowed. Now, bank is deemed to know that you can borrow only up to the amount it is written in the amount of resolution. The amount that is mentioned in the resolution, that much only you can borrow. Articles of association were registered with Companies House, so there was a constructive notice. In AOA, it was written that by passing a resolution, the members or the shareholders will tell you how much you can borrow, right? And this was written in articles. Articles are free to read by anyone. So bank should have read that. But the bank could not be deemed to know which ordinary resolution is passed because these were not registrable. I told you special resolutions are registered, but ordinary resolutions, which are for your general objectives, they are not registered. Bond was valid because there was no requirement to look into company's internal working. Why do you have to go into company's internal working if they have allowed in the articles of association that the directors can borrow the money from bank? You have to keep that only. If limit is given in articles of association, then you go for the limit. It is not written anything about the limit. Then why are you going into internal affairs of the bank company? You just give them the loan, whatever amount is there, they will be repaying it to you. This is the indoor management rule, that the company's indoor affairs are the company's problem. Whatever matter is there of company that they need a resolution, in the resolution amount should be given, how much they can borrow. This is company's internal affair. Bank does not have to do anything. Bank should know that the directors can borrow the money only after the resolution is passed. Now resolution is passed, that is their internal affair. You lend the amount, you give the loan, that is only what you have to do. You don't have to enter into their internal matters. Whatever internal affairs are there of the company, that are company's problems, not other people's problems. Is this case law clear to you people? You need a explanation again or anything? Gopika says clear. Lakshita, Sharmita? Okay, now, but there are some exceptions to indoor management that will say that you should have the knowledge of the internal affairs also. Thus, you will notice that the aforementioned rule of indoor management is important to person dealing with the company through its directors or other persons. They are entitled to assume that the acts of directors or other officers of company are validly performed if they are within the scope of their apparent authority. So long as an act is valid under the articles, if done in a particular manner, an outsider dealing with the company is entitled to assume that it has been done in the manner required. Doctrine of indoor management exception says that it is assumed that the acts that are done by officers, directors of the company, they are within the scope, they are within the authority that has been given to them. And it is assumed that the company, the directors are doing any activity in respect or in accordance with their articles of association and memorandum of association, and they're doing it in the manner it is said. You can't say that like if they are taking a loan, that should be taken in all legal manners, in the legal way. You can't say that this company Reliance is going, Mr. Ambani is going and putting the SBI manager on gunpoint and telling him to give the loan. So it is assumed, we assume that the company is doing all the right ways and in a proper manner they are doing their duties. The above mentioned doctrine of indoor management or Turkant rule has limitations of its own. This is to say, it is inapplicable on following cases. Now, it is inapplicable in this following cases. Now, what are these cases? Actual or constructive knowledge of irregularity. You already know that something fraud is going on in the company. So that is actual knowledge you have of some irregularity. They are not filing their returns on time. They are not giving the loan repayment money on time. So this is actual irregularity. Now, we took the example of ESOPs, but we got to know that Tata Motors promises to give the ESOPs, but they actually do not give ESOPs. I was applying, see, Rushali applied. I applied for the post of analyst and I got to know they will also give us ESOPs. But Rushali's friend is also an employee in Tata Motors, right? And she told they just tell you that they are going to ESOPs. They do fake promises. No ESOPs are given to us. So you can say over here that when fake promises or irregularity comes to a picture, you can't take the help of doctrine of indoor management that I was not aware of the internal affairs. You knew about it, na? That you know actually what is happening inside the company. So that is where this doctrine of indoor management will not apply. The rule does not protect any person when the person dealing with the company has noticed, whether actual or constructive, of the irregularity. Whether they have heard it, read about it, in the news it came that they are promising you ESOPs and they are not giving you ESOPs. So that is also where you can say that you can't say that we are taking the help of doctrine of indoor management. Okay. Is this point clear? Exception number 1 clear? Is the first exception clear? Okay, I will have to go and check. Yes, thumbs up is there. Fine. Let's go with the next one. In Harvard versus Patent Ivory Manufacturing Company, where the directors could not defend the issue of debentures to themselves because they should have known that the extent to which they were lending money to the company required the assent of general meeting, which they had not obtained. Here what has happened? Directors could not defend the issue of debentures. They issued some debentures, but they could not defend this case to themselves because they should have known the extent to which they are lending money. They should know, like if they can only lend debentures of 50 crore, so they will only lend to this amount. Beyond this, they should not be lending any money to the company, required the assent of general meeting. And if they want to lend anything beyond 50 crore, more than 50 crore, they have to take approval in general meeting. Okay, if they had not obtained this approval, then they are going wrong. They know already that they have to take the permission. So here doctrine of indoor management will not apply. Likewise, in Morris versus Cansale, a director could not defend an allotment of shares to him as he participated in the meeting which made the allotment. His appointment as director also fell through because none of the directors appointed him was validly in office. Now, one director was appointed in the case of Morris versus Cansale. Now, this director was given shares of the company, but his appointment was only not valid because there was no other director present who will make the valid appointment. For a valid appointment, you need your executive directors, your independent directors, etc. But these people were not available when the appointment was being done. So that is the case where you can't say that doctrine of indoor management will apply. You will say that you already knew that the directors are not sitting in the meeting. So how can you say now I am appointed as directors and the shares allotted to you are also not correct? Are these two case laws clear? Gopika, Lakshada, Sharmita, are these two case laws again clear to you people? Please respond. There is something. Repeat the second one. Okay. A director could not defend an allotment of shares to him as he participated in the meeting which made the allotment. Now, what happened in the general meeting? They allotted some shares to a director, Mr. Anand. Right? They allotted some shares to Mr. Anand. He is the director of the company. His appointment as director also fell through because none of the directors appointed him was validly in the office. This Anand, we are saying he is the director. But if he was appointed on 1st of May 2024, this is a holiday in Maharashtra. He is running a company in Maharashtra where he is a director. So this is a holiday. And you are saying that Anand was appointed on this date. Anand was appointed as director. Now, Anand, how he will be appointed as director? This is a holiday. No other directors are available in the office. So, if no other directors are available in the office, how we can say that Anand was appointed as director? This itself is a false statement. This itself is not valid because these other directors who will be appointing your new director, they are not there in the office. So, Anand's appointment as a director becomes invalid. Therefore, if in the other general meeting Anand says I am the director and he takes allotment of shares, that won't be valid. Okay, is this point clear now? Now, suspicion of irregularity, when you already know that there is some irregularity. Now here in the previous case, what happened, you already know that no director was present over here, so whatever shares will be allotted to you, you can't be considered as director, and the shares are allotted to director. Where your appointment is valid? Your appointment is not valid because other directors were not there present in that meeting, board of directors meeting, so your appointment is also not valid. This was the already knowledge you have. You knew the actual irregularity. Next is you are suspecting of irregularity. You know that some fraud is going on. You are not having the actual knowledge, but you suspect it. You have a doubt about it. The doctrine in no way rewards those who behave negligently. You already had a doubt now. So why did you enter into that company? If I am applying for a job in a company, I know there is some fraud being going on in that company. Why should I apply over there? If I apply to Credit Suisse, now Credit Suisse, I already know is going to be taken over by UBS because it is not performing well. So why will I apply in Credit Suisse? I will directly apply in UBS because I know it is going to be taken over by UBS. I already know this is not performing well. I have a suspicion, I have a doubt that Credit Suisse is not performing well. There is some irregularity in Credit Suisse. So I should not apply there. The doctrine in no way rewards those who behave negligently. I already had a doubt that Credit Suisse is not performing well. Still, I go and apply there. Still, I am being negligent about this. So that is called as suspicion of irregularity, where the person dealing with the company is put upon an inquiry, for example, where the transaction is unusual or not in the ordinary course of business. It is the duty of the outsider to make the necessary inquiry. When a person dealing with the company is put on inquiry, for example, where the transaction is unusual, I know that this company is doing something wrong, still I apply it. This transaction is unusual, where there every person is leaving that company, I am going and applying for a job over there. So this is an unusual thing or not in the ordinary course of business. It is the duty of outsider to make necessary inquiry. So my friends see that I am applying to a company where no one is applying, where people are leaving the company and still they are going to hire new people at 10 CR, 10 lakhs of package. So if that is going there, other people can take an inquiry. They will try to ask people, why are they hiring new people and at 10 lakhs package, which is very much high. They don't have that much money also. Still they are hiring at 10 lakhs. How is it possible? The protection of the Turkan rule is not available where the circumstances surrounding the contract are suspicious and therefore invite inquiry. So your Turkan rule, doctrine of indoor management, will not be available over here where you already have the doubt and you are thinking of doing some inquiry over here. Suspicion should arise, for example, from the fact that an officer is purporting to act in matter which is apparently outside the scope of his authority. Where, for example, as in case of Anand Bihari Lal versus Dinsha and Company, plaintiff accepted a transfer of company's property from its accountant. The transfer was held void. Plaintiff could not have supposed, in absence of a power of attorney, that the accountant had the authority to effect transfer of company's property. Now, in Anand Bihari Lal versus Dinsha and Company, what happened? There was a person who is the accountant of the company. He is trying to transfer the property of the company. Now, can your accountant transfer the property? No, directors have the power. They can transfer a property if they want. But if an accountant who is doing a job 9 to 5, he is accounting the books of account, he transfers you the property. That is an invalid thing. That is a void kind of thing that you are getting into. You should get a doubt that your accountant does not do this job. Accountant's job is to manage the financial statements. This is not the duty of it. Still, if you are entering into this transaction and other person gets to know that this transaction is being done, he will start an inquiry. Clear? Suppose in A Limited, Raj is the accountant and Raj does a transaction with Abhishek and he transfers him a land. He transfers him a land. Now, this land is being transferred by the accountant. This accountant does not have the authority. With this accountant, there is one more employee working who is HR. Right? You know, HR, human resource department in the companies who are recruiting the people. So this HR, what he does, he gets to know that Raj is the accountant and he's transferring land. He's transferring the land to Abhishek. HR will go to the directors and inform them of this fraud that is going to be held, the fraud that they are doing, and then they will start the inquiry. Is this example clear? Instead of the name that is given in the case law, I used different names for your understanding. Similarly, in the case of Houghton and Company, what happened, Lakshita? Similarly, in the case of Houghton and Company versus Northard, Louis and Willis Limited, there a person holding directorship in two companies agreed to apply the money of one company in payment of debt of another. Court said that this was something so unusual that the plaintiffs were put upon inquiry to ascertain whether the person making the contract had an authority in fact to make it. Any other rule would place limited companies without any sufficient reason for doing so at the mercy of any servant or agent who should purport to contract on their behalf. Now, what happened? One director, if you can say Avi, is the director in A Limited and B Limited. So A Limited freshly took a loan of rupees 100 crore on 20 May 2024. Now, on 20 May, they took the loan, but on 22nd May, 23rd May, they are not going to be working. 23rd May, till 23rd May, there is company holiday. Now, what he says, this 100 crore is available with me. I will use this to pay the loan of B Limited on 22nd of May. For 2 days, I will use this money. On 24, this A Limited will start working. Till then, I will recover the money from B Limited. One money is transferred to another money, another company's money, where it is required. Director of A Limited, Avi, transfers the money to B Limited, where also he is a director. For the time being, he makes the wrong utilization of the money. That is where you can say that doctrine of indoor management will not apply. Here he does not have the right. If the other people come to know, A Limited employees come to know that he has used this money from A Limited in the B Limited, they will start the inquiry about it. And they will say, let us check, is Avi authorized to do that or not. If Avi is an actual person, is an actual director who has the authority to do this thing, and any other rule would place limited companies without any sufficient reason for doing so at the mercy of any servant or agent who should purport to contract on their behalf. Now, they will not allow such person to do this activity without any sufficient reason. If you are transferring the money from one company to another company, this should be a loan transaction, but you are taking the money and paying off the debt of another company. When the money comes back from this company, you will keep it in the bank account of A Limited. So this is not a sufficient reason that you are transferring the money without a reason. You are not informing other people and transferring the money. Okay. Is this example clear? Forgery. The doctrine of indoor management applies only to irregularities which might otherwise affect a transaction, but it cannot apply to forgery, which must regard as nullity. Now, if some forgery has been done, if some fraud has been done, you are signing the documents by fraud, then doctrine of indoor management will not apply. Forgery may, in circumstances, exclude the Turkan rule. The only clear illustration is found in the Ruben versus Great Fingal Consolidated. In this case, the plaintiff was transferee of share certificates issued under the seal of the defendant's company. The company secretary who has affixed the seal of company and forged the signature of two directors issued the certificate. Now, one company's share certificate are transferred, and see, this is your company. You can take it as Great Fingal, right? Great Fingal gives share certificate. They bought the shares. Ruben bought the shares and he got the share certificate. Right. This share certificate had the sign of two directors A and B. But these signs were not actually done by A and B. This was done by the secretary of the company. And she also placed a common seal. She also placed a common seal of the company. So which is also against the law. She has done forgery. Secretary Miss M Secretary, Miss M, has forged the signatures of A and B and has also placed a common seal of the company, Great Fingal, on the share certificate and has given it to Mr. Ruben. So here the activity was of forgery. So the certificate that is issued is invalid because A and B did not sign this document and the common seal was not imposed in the favor or in the eyes of A and B in front of Mr. A and B, the actual directors. Is this example clear to you people? Gopika Lakshada Sharma. Okay. Let's go what's ahead. The plaintiff contended that whether the signature were genuine or forged was part of internal management, and therefore the company should be estopped from denying the genuineness of document. But it was held that the rule has never been extended to cover a complete forgery. What Ruben will say? Ruben will say, I don't know that the signs were forged. He will say, I don't know the signs were forged. They were done by doing some wrong or forgery. I don't know. You give me the shares. These shares are mine. What they said is, what the court said is, you can't take this rule. You can't say that exception to this rule is you can't accept complete forgery. If the signs are forged, the document will not be genuine because it was done by fraudulent activity. It was done by forgery. So the genuineness of document is in question over here. The document is not genuine. If the document is not genuine, you are not a shareholder because the document is invalid. Document is fake. Okay. Is the example clear to you people? Okay.
Yes, ma'am.
That was it about doctrine of ultra wires and doctrine of indoor management. I hope it is clear to you people. Any doubts, anyone?